have you pinned. Okay. All right. Good afternoon, everyone. Welcome to today's ADA training. It looks like a few folks are still actually joining, so let me give it a couple seconds. Make sure everybody can get in. All right, so let's go ahead and get started. My name is Peggy Cadwell, and I am the statewide Title II ADA coordinator for the New Mexico Administrative Office of the Courts. Before we begin today's presentation, I have a few announcements and a few reminders. Today's presentation is going to be recorded and is going to be posted in the New Mexico Language Access YouTube channel for those of you who are not able to stay for the entire presentation or who would like to share the presentation with other folks. Oh, let's see. So today we have an ASL interpreter available. Megan, welcome, and thank you for agreeing to help us today. Professor Adelson will be available after the presentation to answer any of your questions. You may post your questions in the chat box or ask them, unmute yourself and ask the question. We also like to remind everyone that today's presentation is for informational purposes only and does not represent legal advice. Also, please stay tuned. We're going to be sending out future training opportunities and we'll be sharing those with you. Please feel free to share those with your coworkers. I know that we have a lot of folks joining us from other states, and I'd like to welcome you today and ask you to, if you can, just tell us in the chat box, where are you joining us from today? I also like to thank all of New Mexico judiciary employees and judges for their commitment and their hard work. Your efforts are helping us become more accessible. So today's training is accommodating jurors with disabilities and courthouse accessibility. Please join me in welcoming Professor Bruce Adelson. Professor Adelson is here today with help us with this topic. But before we jump into that, just one more thing. For those of you who are seeking ACTCP CEUs, you may request those from Annie. If you can just make sure to let her know that you need CEUs, and we can help you with that. We just need you to make sure that you remained during the presentation with your camera on, and just let her know. And she's going to put her email address in the chat box for those of you who need CEUs. Anyway, all that to say, welcome Professor Adelson today. As always, it is a pleasure. Please go ahead.
Thank you, Peggy, and good afternoon or good morning to all of you. It's a pleasure to see you today. And as Peggy said, we're going to be talking about jurors with disabilities and courthouse accessibility issues under the Americans with Disabilities Act. One very quick bio about me. I'm a former U.S. Department of Justice senior trial attorney, Civil Rights Division. During my time at Justice, my primary enforcement for language access was with state courts. I am the ADA consultant to the New Mexico Administrative Office of the Courts, and I'm on the faculty at the University of Pittsburgh School of Law and Georgetown University School of Medicine. So with that, I'll begin. And as Peggy said, please hold your questions until the end. There's a lot of information that I want to get through, and here we go. Okay, so very briefly, the Americans with Disabilities Act under Title II really applies, I would think, to all of you as representatives of local or state governments. ADA, Title II of the ADA only applies to public entities, and also to federally subsidized healthcare providers under the Affordable Care Act. The ADA, in brief, was first enacted in 1990, amended in 2008. No disability discrimination in places of public accommodation. That's ADA Title III. That's like private businesses like restaurants and hotels, for example. No disability discrimination by state and local governments, ADA Title II. You do not need a federal subsidy to be covered by the ADA. All you basically need is to have a business or public entity or organization that is open to the public. Effective communications accessible to all is a major part of the ADA, requiring sign language interpreters, for example, as well as other auxiliary aids. My friends at DOJ put out some good guidelines in 2014 about effective communications, which I regularly use. I think it's one of DOJ's better and more succinct guidances. So with that, let's look at what the Court of Appeals, U.S. Court of Appeals for the Ninth Circuit, which covers New Mexico and several others of you too who are here today, about the ADA and local governments. The Ninth Circuit holdings are the same concerning Title II as in all circuit courts of appeals throughout the U.S. We have explained that the broad language of Title II brings within its scope anything a public entity does. So what that means, for example, is you're not required to have a website for your court, but if you do have a website, that does come under the ADA, Americans with Disabilities Act, and its website accessibility requirements. So the scope of ADA Title II is very broad, much broader than the private business Title III. And I think that really informs a lot of what we're going to be talking about today. In looking at accessibility in general for the courts, it's important to recognize that the U.S. Supreme Court, on at least 2 occasions, has held that members of the public have a constitutional right of access to state courts, excuse me, both to serve on, to be in the audience, for example, and to be able to access both civil and criminal trials. So that plus the ADA really make it very clear that access to the courts is a fundamental right and requirement for local and state governments. With that in mind, let's look at a story that was in the Denver Post earlier this year about a situation where a juror with a hearing disability was denied access to serving as a juror. That is per se discriminatory under the Americans with Disabilities Act, but there are a couple of interesting twists to this case that I wanted to bring up. So, a Denver district court judge had determined that the juror in question, whose name is Spencer Kontnick, could not serve on the jury because he had a hearing disability. Now, what I find most interesting is that the key facts are in the first paragraph, which I think are rather quite stunning. So he reported for jury duty one day, met the court-appointed interpreter, was told to wait outside the courtroom while the judge met with the lawyers. So both the prosecutor and the defense attorney came up with a written agreement that they presented to the judge that said that the prospective juror should be excused. And they cited, as you can see in bold in the middle paragraph, that because things might be tough for him if he serves on a jury. It's just stunning to me that both attorneys, as well as the judge, didn't seem to understand not only what all the requirements are for accommodating jurors with disabilities, but to suggest that things might be tough for him if he served, which certainly is among the topics that I discuss with my students about bias, that to make a statement like that, an assumption like that, is really noteworthy and quite remarkable. So, Mr. Kontnick sued the judge and the court, claiming ADA discrimination. The Denver County, in defending against the case, said that the judge has excuse me, immunity and can't be sued. That is incorrect. The judge is not being sued for money damages. To suggest that state or local court judges have immunity from suit if their courthouses or courtrooms are inaccessible really turns the ADA on its head. So the judge who is presiding over the Mr. Kontnik's lawsuit, of course, excuse me, dismissed the county's arguments and did hold that the judge and the county could be liable for ADA disability discrimination, which in this context would basically mean some type of injunctive relief of requiring the county and the court to become accessible and to no longer prohibit jurors from serving because they have a disability. In discussing this, I thought one of the things I wanted to discuss was this case out of New Jersey that involved disability discrimination in 2016. I'm going to get into a little discussion of what happened in that case in a few more slides. But for your information, to prove a prima facie case or a per se violation of ADA Title II, the plaintiff only has to show these three things: that the plaintiff is a qualified individual with a disability, that he was excluded from the service, program, or activity of a local or state government, and that he was excluded because of his disability. Clearly, that applies to Mr. Kontnik in the Denver case. It did apply to Mr. Perez in the New Jersey case, which we'll see in a minute. So proving an ADA Title II violation on the surface is not that difficult, or as difficult as proving a discrimination case under other statutes. To show that the plaintiff was excluded from a service or program, showing or proving that the local or state government failed to provide, as you can see in the first paragraph, quote, appropriate auxiliary aids or services to afford that individual with a disability an equal opportunity to court services would be one of the elements of proof. And under the ADA Title II, there's something called the primary consideration rule, as you can see cited in the second paragraph. The primary consideration rule, in short, means that if I have a disability, a communication disability, for example, and I communicate by American Sign Language, then you must give me an American Sign Language interpreter, all other things being equal, meaning that it's not an emergency, there's not some type of crisis where a sign language interpreter may not be immediately available for some reason, which frankly, in today's world of video remote interpreting and Zoom meetings, is probably not as likely to happen as it might have been a few years ago. But that primary consideration rule is unique to ADA Title II. It's not in ADA Title III. So the standard for you to meet is already a high one. You essentially have to defer to me and what my communication preferences are, unless they would change the operation of the court or constitute some kind of undue burden. I've never seen that work in an ADA Title II case. Even in an ADA Title III case, it's pretty hard to establish undue burden as a reason why you're not providing the preferred accommodation of someone with a disability. And this is a little excerpt from the federal court decision in the Perez case. So as you can see, Mr. Perez came to court in 2013. Excuse me. And he had several court appearances where he wasn't provided with an interpreter. He had notified the court that he was deaf, communicated by American Sign Language, and needed an interpreter. That, of course, should have been the end of the inquiry, but it wasn't. So Municipal Court Judge Burkett explained that there were no interpreters available because of financial reasons. The plaintiff's attorney, public defender, claimed that the plaintiff had been unable to attend a court diversion program that he was ordered to attend because he could not afford his own interpreter. But then the court instructed the plaintiff to complete the program anyway. Of course, as someone with a disability is not required to provide their own interpreter. That's an obligation of the state or local government. The judge stated that an interpreter would not be necessary at the next court hearing because all Mr. Perez had to do was simply bring documentation showing attendance. Now you can imagine, so that would mean there'd be no communication between the court and Mr. Perez, that just give them the piece of paper. There's no talking, there's nothing. So if Mr. Perez has a question, of course, you can't ask that because there won't be an interpreter present. So the Judge Burkett was clearly incorrect here, as well as other court officials, and the opinion went along to have some other examples. But this is a good example, I think, of a misunderstanding of ADA requirements under ADA Title II to provide an interpreter, particularly with the primary consideration rule. So for exclusion because of the disability. So what does the law actually say about that? Law is pretty clear. As you can see in the first paragraph, these are just some of the courts that have decided or have held that deaf individuals cannot be disqualified from jury service solely because of their disability. That's a significant ADA problem. And as you could see with the Supreme Court cases I discussed earlier, that's going to be a problem under Tennessee versus Lane, for example. You just can't do it, period. And then in the second paragraph, there are some academic and related treatises about the whole issue of jurors with disabilities and state and local courts. So these court decisions out of New York, I think, give some good examples of when a court is faced with a situation where a prospective juror has a communication disability. Well, what do? Well, one of the things that you do is have, inquire of the juror, prospective juror, what are your communication preferences? These are today, or as a juror, you will be tasked with doing X, Y, and Z, some type of individualized communication so that the court can determine that the juror understands what their roles are. The juror has communicated with the court about what their communication needs are. And there's been a good, thorough, interactive conversation to ensure that the juror does have ADA required auxiliary aids and services to enable communication. So having this directed conversation, in the sense of having a good interaction with the prospective juror, is a good idea, and certainly is required in other parts of the ADA. And I think that would be a best practice in these situations. Further along the same lines, out of a case out of Massachusetts, as you can see, the judge conducted an individualized voir dire of this particular juror, number 6, determined that he was competent to serve. Furthermore, the judge furnished with the input and approval of the juror the auxiliary services that would enable his service. So having that individualized conversation, directed conversation, individualized voir dire, however you describe it, is a good idea. And that you can put on the record all the efforts you made to accommodate the juror, the interactive conversation, what type of auxiliary aid the juror requested, and the courts being able to supply that. So I'm a big fan, and I learned this during my federal service with DOJ. Having a really full record is very important for many reasons. So this is kind of a cue to do so if you are faced with a juror with a communication disability. These are some quotes from the DOJ's 2014 guidance. And you can see DOJ suggests auxiliary aids and services for jurors, or for jurors who are blind, have vision loss, deaf-blind, and also deaf and hearing impaired. So in the second paragraph, there are suggestions about, well, if you're faced with someone with a visual impairment or is blind, for example, or low vision, what are the types of aids and services that you may look to have available to provide? Large print information in Braille, or electronically for use, a computer screen reading program, or a recording of printed information. A qualified reader means someone who is able to read effectively accurately and impartially, using any necessary specialized vocabulary. So these are good suggestions, all endorsed by the Department of Justice for jurors who have visual disabilities. And for someone who is deaf, for example, has hearing loss, deaf blind, the suggestions are qualified note taker, qualified sign language interpreter, oral interpreter, acute special interpreter, tactile interpreter. So you can see in the first paragraph the suggestions that again, the DOJ is making, and their definition of qualified interpreter means someone, as you can see, who has the ability to act impartially, to convey information back and forth, and has the necessary specialized vocabulary. And that, as you know, is key. That just because you speak a certain language, just because you communicate or can communicate in American Sign Language, doesn't necessarily mean you have specialized vocabulary for the courtroom. That would include, for example, what the translation for summary judgment, for voir dire, for jury trial, for evidence, for rules. All those things are good examples. So having that specialized vocabulary is important to not only comply with the ADA, but to ensure that the person with whom you're communicating does receive the effective communication that is the hallmark of the ADA and is required. The National Center for State Courts also has some good information, and they have some suggestions about the accommodations that can be used to communicate with people who have communication disabilities. So as you can see, they, in doing some various interviews and studies, it's important that jury managers are aware of the range of accommodations, some of which we talked about in the previous slides, that are available, but also know where to get them. So they also recommend, which I endorse, having many of them available in the courthouse for use. And that can eliminate undue delays, which is very important. And as you can see in the second paragraph, the rationale for having these services available is it maybe an accommodation request hasn't been made in advance, a day before or 2 days before, maybe it was just made now. So being able to accommodate the person with a disability as quickly as possible is facilitated by your having these services on hand. So there's no, of course, requirement that you have to have everything available for every particular contingency. But knowing which are the likeliest to be used, which are the most effective for providing effective communication, I think that would be a good idea to explore having several of these devices, these auxiliary aids and services available in person for use if the need arises. I know that one of the ongoing issues we had when I was with Justice was delays that can turn into significant delays, but even more poignantly, turnaways, where people with disabilities or people who are limited English proficient are told to come back another day because we just don't have the computer working. We don't have a screen reading device available, and it will take a day to get one, for example. That's just not good. Turnaways because you're not prepared to fulfill your ADA obligations, where the person in a protected category, here someone with a disability, is not able to access court services immediately or as quickly as possible. So those always were big red flags for us. And I would keep that in mind as you're planning your compliance with the communication mandates of the ADA and also other federal laws like Title VI of the Civil Rights Act of 1964 concerning spoken languages. So what's also important is that last sentence. Although the court is not required to provide the best possible accommodation, whatever that may be, the accommodation must be reasonable, and I would add to that, must provide effective communication. So for example, written notes can provide effective communication in certain circumstances, which would include, for example, me as someone with a disability, being able to read and communicate and write in English so that I can understand, if you're doing that with me, what you're saying to me, and that the conversation is not lengthy and does not include a lot of complex arguments like, well, what does the due process clause of the 14th Amendment actually mean? Simple directions like, where is the courtroom? When will the trial resume? Basic information like that. Getting into complex conversations, writing just note after note after note is not going to work. So keep in mind, this is an individualized, fact-intensive, and specific determination. What aid or service works in a given situation with a particular individual. So the accommodation must be reasonable given the context and provide effective accommodation. So these are the suggestions of the National Center for State Courts on possible accommodations for people who are blind or have low vision. And they, for the most part, track what DOJ recommends. Optical magnifier, large print materials, a brailler or braille note-taking computer, electronic note-taker, or service animals. And for people who are, according to the National Center, hearing impaired, there's this list, which is a little more, and it looks bigger than what Justice said, but they're basically the types of communication all fit within the categories that DOJ had recommended. So looking at the list and saying, well, which one of these do we have? How many of them do we have? How often are they used? Are they effective? TTYs are generally not really used much anymore, but they are listed as an aid or service by the ADA. And DOJ still includes them in their regulations, which haven't been revised in a while. So if someone comes in and asks for a TTY, do you have to provide it? Remember, National Center said, and I think this is true, that the accommodation, that doesn't have to be the best one, but it must be reasonable and effective under the circumstances. I have not heard for several years now someone actually asking for a TTY as an accommodation. There are more objectively effective alternatives, but keep in mind that TTYs are considered an ADA accommodation until DOJ gets around to amending their regulations and bringing them more up to date than the regulations from the 1990s, for example. Okay, so now we're going to talk about courthouses. Physical accessibility. So this is obviously a significant issue in this picture. Where is the accessible entrance? A staircase is not accessible to someone in a wheelchair, for example. The next few, I think the next 3 slides have pictures of various courthouses that I've had the opportunity to visit with some accessibility examples. So let's start with this. Now, on the left, the restroom is clearly not accessible. On the right-hand side, opposite the toilet, there is a cabinet which cannot be moved. So you already have an issue of not having enough of room for someone in a wheelchair to have an adequate radius to navigate the area in the restroom. There are other issues here too, but that's one of the more obvious ones that stand out. There's just not enough room between that brown cabinet, which is, I think, bolted to the floor, and the toilet to comply with the ADA. On the right is a metal staircase that's an emergency exit. That's from the first floor. The first floor of this particular courthouse was somewhat elevated. So the only means of egress, of exit in an emergency is this metal staircase, which would clearly be problematic for someone with a physical disability, for example, a mobility disability. And here you have what I find most frequently are problematic are jury boxes. On the left, you can see there are that's the jury box that has the kind of maroon carpeting. You have no space for a wheelchair in the jury box, but also you have steps. And the height of the steps, certainly the height of the step at the bottom of the screen, exceeds ADA requirements. So this is not an accessible jury box. On the right, that jury box is better. There is room for a wheelchair. They left space between that glass yellow chair and the end of the box. The problem may be that the bar at the front that may impact the amount of room that a wheelchair is required. A wheelchair is required to have to maneuver into the space. It may not. It just depends what the dimensions are. But one of the suggestions that I would have: why do you even have the bar there? I would just take a nice power saw and cut through that last remaining part of that bar. That way, you're not going to have any problem at all. Because even if the dimensions are good the way it appears now, when you take that bar out, you're like guaranteed not to be having any kind of space constraints or ADA violations for an inaccessible jury box. And these are some of my ongoing, again, things that I see all the time. Excuse me. If a door is too heavy, courtroom doors sometimes are very heavy. They're big wooden doors, and they're going to be difficult to open for anybody, whether you have a disability or not. So that will mean ensuring that the doors are automatic. Because if I have a disability and I can't open the door, then your court program, services, and activities are not accessible to me. In the middle is a handle for a door that I see an awful lot. It's a twist handle, and I have to grasp it and then pull it down. Those types of handles are considered inaccessible under the ADA. The restroom at the end of the slide, that flat panel, that can be a good way to have an accessible door opener. But again, the door can't be too heavy. If it's too heavy and I'm unable to open it, then looking at a remote automatic door accommodations is probably the way to go. But I invariably find those twist handles and doors that are too heavy and exceed ADA requirements, or they don't meet ADA requirements. They're heavier than what the ADA allows. Now let's talk about, this is a Ninth Circuit case that I'm using just to illustrate the issues that come up in an accessibility review, survey, or court case. So in this particular case of Corolla from 2017, and the case is still ongoing, I believe. These are issues about the parks and recreational facilities, libraries, pools in the city and county of San Francisco. So in this case, and in various iterations of this case, there are literally lists of public facilities with various complaints about inaccessibility. For example, the example, I'm sorry, is on the next screen. As the decision in Corolla makes clear, the slightest access barrier in a government facility may serve as a basis for a class action lawsuit against a local government or agency, because that barrier is preventing that access to your program, services, and activities. Second paragraph is a suggestion for how you get ahead of this. Having a self-evaluation of your accessibility status is a good idea. And that goes back to when the ADA was passed in 1990. So the idea of a self-evaluation is frankly more than 30 years old. And many of the organizations, both public and private, that I work with and have worked with have not done these self-evaluations. So getting an idea of your universe of accessibility considerations and potential problems is very important, not only for your own planning, but in case there's a complaint or an issue that arises, you can point to, well, we're doing it, we've done it, or we're getting ready to do it. All of those things are very important to show the Department of Justice or potentially a court that you're not acting with intent to discriminate, and that can be significant depending on what the facts of an individual case are. But I know I've heard so many times, I heard it, others have told me, that for local and state governments, recipients of federal funding, to show that they understand what their obligations are, they take them seriously, and they're taking steps to ensure compliance. As we learned earlier, that this is a class action lawsuit, and Ivana Carolla has cerebral palsy, filed this lawsuit concerning the city's, as we talked about, public libraries, pools, recreation and park facilities, pedestrian rights of way, a lot of claims in this case. And these are some examples of what are alleged to be violations on behalf of the city and county of San Francisco. And I would suggest, in looking at these, think about whether these are issues that you've seen, you've heard about, you've had complaints about, or you've addressed at your facilities. So 3 stretches of sidewalk containing bumps, these bumps, elevations, or concrete spalling where the concrete has holes or gaps or damage, they can be real problems for somebody with a visual disability using a cane as an assistive device, or someone in a wheelchair. Hit one of these bumps or holes, and there could be a significant accident involving significant physical harm. And that's aside from the ADA requirement. A sidewalk where her wheelchair became stuck in a tree well. I saw that should have reminded me. I did a survey of a hospital in the Southeast, and they had a long walkway that at several points the roots of nearby trees had broken through. So it would have been impossible for someone who is blind or in a wheelchair to navigate this pavement on their own, because there are all these impediments, significant impediments, and the roots were pretty big that impacted the accessibility of the sidewalk, and indeed made the sidewalk inaccessible in numerous points. Street corner that lacked curb ramps, street corner that provided only a single curb ramp, errant step stools at 3 of the city's libraries, 3 inaccessible pools, and steep paths in 1 park. And these are right out of the Carolla court decision. So just enumerations of accessibility issues that are different from the jury box that has a step up, the jury box that has a footrest that may impact the area for a wheelchair to navigate. So, but these are also significant ADA issues and matters of concern. In this case, the Ninth Circuit reversed the trial court and held that someone bringing a claim under Title II of the ADA can prove that they have the standing, they have the right to sue by showing evidence that they encountered an access barrier of any degree, and that deterred them or from returning to the facility or prevented them from using the facility at this time. The Ninth Circuit further held that a plaintiff in a case like this has established standing to bring an ADA accessibility claim. That person can proceed with the class action lawsuit, even against barriers not personally encountered by this individual. Now, some of you may know the U.S. Supreme Court has agreed to hear a case next term about people who are, I guess, the court, briefing described as a serial filer. People just file a lot of lawsuits, and whether or not they have standing. That would impact the Carolla decision here, but for now, if the Supreme Court restricts standing, that someone with a disability in the Ninth Circuit could bring a class action, have the class action certified by alleging certain ADA accessibility issues, whether or not they've personally encountered. And further, this is, I had said earlier that the case is still going on. I use this to illustrate that the plaintiff, they came to court again with just I think this might have been in February. Again, a list of various accessibility issues. And as you can see in the second paragraph, the appeals court ordered that the trial court evaluate the evidence of alleged violations in the facilities, and that any evidence regarding the MLK pool restroom, stalled door latch, the lower court should order that this be taken care of. And if the district court finds any other ADA violations, structural violations, the court should revisit the question of injunctive relief. So the ADAG is short, if you don't know, for the ADA accessibility guidelines. Those are promulgated by the Department of Justice and are federal regulations, so they are legal requirements. There are hundreds, if not more than that, of requirements in the ADAG for all kinds of things, including the height of a water stream coming from a water fountain, just many, 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 many requirements. If you're not familiar with that, the ADAG, I commend reading it, or at least familiarizing yourself with it. This is another case that kind of follows along the same path as Corolla Guadagnini versus Samtrans at the Northern District of California. And again, I use this just to illustrate the listing of various areas, complaints, and issues. So here there are bus stops, and they have the addresses for the bus stops that the plaintiffs are alleging are inaccessible. So that's typically what happens in ADA cases. This can be a very lengthy list of issues and problems, as we saw a couple of slides ago in the Corolla case about the bumps on the sidewalk and other related accessibility issues. So that when you're evaluating your own facilities, these evaluations include essentially making lists of what are potential issues, what are ADA violations now. This case has some significant implications. This was a class action lawsuit filed in the Eastern District of Michigan at the end of last year, I think in December. Babcock versus the state of Michigan and several counties. This is significant because of the number of violations that are listed by the city of Detroit, Wayne County, where Detroit is, several other counties, the Michigan Supreme Court building. The next few slides will just show you again as illustrations the types of issues that are alleged here. And many of these issues are issues I see all the time, and they tend to have commonalities in different locations, different states, cities, public organizations, and private organizations as being pretty common, and issues that have often not been addressed. An example of and the next several slides will have other examples like this: accessible bathrooms, not having accessible entrances. An accessible entrance does not include revolving doors. A revolving door is not accessible. Having the only means of going from one level to another, having that be an escalator, that's not enough. An escalator is not going to be accessible, or having moving walkways, also not considered to be widely accessible. And so here you have some issue allegations about parking areas. Parking areas are always issues, and something DOJ will look at in virtually every examination that they do. And it's not difficult to find problems, but having a parking lot that doesn't have enough accessible spaces, for example, that has broken concrete, no curb cuts, not having signage about the van accessible parking spaces, for example. All of those are very typical ADA problems, and also having spaces that are not wide enough. This also involves the state Supreme Court building. And again, issues of accessible bathrooms, concrete, not maintaining a concrete ramp into the building. That may suggest broken concrete, for example, and not having sufficient parking areas that are accessible. Michigan Hall of Justice, again, the not having enough signage. Signage is an easy one. You either have a sign or you don't. And having signs that direct people with disabilities to accessible entrances is required by federal law. Invariably, I don't see them. In most of the places that I do assessments or work with organizations, they don't have legally required directional signage. And the 36th District Court, which is the district court for the city of Detroit, in Michigan, district court is the lower level trial court. It's not a court of general jurisdiction. So here, there are no accessible entrances into the facility. That's a big problem. And not having accessible parking or drop-off areas. So if you have doors that are too heavy, for example, a door that's too narrow under the ADA, then rhetorically, how am I, if I'm in a wheelchair, for example, how am I going to access your program services or activities, which will invariably involve going into a courtroom? Of course, not necessarily, but that's a big part of what courthouses do, of course. And this is the Criminal Justice Center. This is also in Wayne County, where Detroit is. Failure to conduct an accessibility analysis, which I take to mean not doing a self-evaluation. Failure to publish and make readily available this compliance analysis and report. Family court. And again, you have the signage issue, parking issue. Valet parking services, that's also a requirement that there be the parking space has to have the correct dimensions. Often I see that valet parking spaces do not have the correct dimensions that the ADA requires. Last one, does not have ready access to the stair lift or elevators. The elevators also have specific ADA dimensional requirements. And these all go to basic access issues for program services and activities. County. So we have a jury box issue, and we have parking issues. Delta County is a relatively small county in a rural part of Michigan. King County is on the Lake Michigan coast in Western Michigan. So let's look at, again, we see the same types of issues. Not inaccessible restrooms, inaccessible parking, insufficient signage, and the evacuation equipment. Remember, we saw that metal staircase as an example of inaccessibility. There was a federal case out of New York a few years ago after some disastrous flooding in New York City that held emergency evacuation plans and emergency evacuation programs must be accessible to people with disabilities. Not a lot of organizations or jurisdictions have incorporated that, but making sure that your emergency plans are accessible and your emergency services are accessible is very important. Livingston County, I think, is in central Michigan. Again, restrooms, the entrance isn't fully accessible, which I take to mean is not accessible, at least by allegation. And again, with the parking. Mackinac County, northern Michigan. So, I could take the names off of all of them. And as you've seen, many of the allegations, if not most of them, are common throughout each jurisdiction or each facility that at least is being alleged here to be inaccessible. Washtenaw County, again, it's the same thing, although the C is interesting that the public entrance is blocked by garbage containers. I did several years ago ADA consultation and an assessment for the Wayne County Airport Authority, which operates Detroit Metro Airport. One of the issues that I encountered there, where there was a path from the garage into the terminal, the path was blocked by salt, big piles of salt that were, of course, used for de-icing and to make surfaces safe. In Michigan, that's a big problem during the winter, but someone just plopped down these enormous mounds of salt on the accessible route from the parking lot to the terminal. It was, of course, it was easy enough to have them removed. They also had left large snow plows on the path, again, easy enough to remove. So when I read that about the garbage containers, it reminded me of the Wayne County salt mounds. But that's also a problem that is easily remedied. Just move the garbage container. This is a case out of Indiana 6 years ago, alleging various facility problems in the Pulaski County, Indiana courthouse. As you can see, the allegations are in the second paragraph. The court certified a class action. Not surprisingly, shortly after that, the case settled. So there were some significant accessibility problems in Pulaski County. And the settlement agreement in Kootenai County, Idaho, which is posted on the U.S. Attorney's website, that alleges, or not alleges, because this is a DOJ enforcement agreement, found various accessibility problems in multiple court-related facilities, both the County Justice Building, for example, and the Juvenile Justice Center. And many of the issues were, as we've talked about, parking, restrooms, doors, entrances. Of course, that's not an exclusive list, but those items were all part of DOJ's findings in this case. I conclude on a somewhat humorous note with two memes. And my son, who's graduating from college in 2 weeks, is my chief digital officer, and he is responsible for providing me with various memes. And one here, I saw some people not listening to the Department of Justice. Yeah, that's cause for being pretty upset. DOJ's put out a lot of good information about the ADA. Following what DOJ says is typically always a good idea. And hopefully none of you are in this situation. Okay, I'm going to sue you now. ADA lawsuits are big business. The ADA remains one of the most heavily litigated of federal civil rights statutes. So hopefully you will not be Woody in a situation like this and be sued. That is my contact information. It's been a pleasure to talk with you today. I think we still have a few minutes. And so Peggy, I'm ready to go.
All right. Thank you, Bruce, for the great presentation. Lots of useful information. And yes, we are listening, or trying to at least, right? That's what counts. Yeah. All right. So we have several questions, Bruce. Hopefully we can get through most of these. Let's see. Veronica Alabas Narin asked, her question is, what if a disabled juror brings a doctor's note in excusing them from service, but sorry, Veronica, that was your question. What if a juror brings in a note asking them to be excused from service?
Yeah, I just put, what if they bring in a doctor's note, because of their disability? Is it wrong for us to excuse that juror? I'm sorry if I didn't word it correctly.
Well be. A lot of doctors think if they write a note that has some legal implications here. And working with a lot of doctors as a faculty member at Georgetown and doing a lot of healthcare compliance, I can tell you that's just not true. So you still need to have that interactive conversation with the juror, and the juror may not agree, but I would not rely on a doctor's note as a defense in an ADA disability discrimination case. So you at the very least must talk to the prospective juror and not give undue weight to what the doctor's note says.
Bruce, the next question is related to this question. Stephen asked, is it an ADA violation if the prospective juror, and I'm sorry, Megan, I'll slow down, requests to be excused from service due to their disability, even though the court can provide accommodations for them?
Yeah, and I would recommend that interactive conversation, just like you do under the ADA in employment situations. Find out more. If a juror, that's really my advice, find out more. As you all know, as court officials, people come into court all the time with excuses to get out of jury duty. So if you decide to excuse a juror who has a disability because of a disability, I strongly recommend having a very good record of your interactive conversation and having the judge put something on the record as the rationale for why you're excusing the juror.
Great. Ashley from Spokane is asking, if a juror is completely blind, how does the court accommodate the need to see exhibits? Great question, Ashley.
It is a great question. I know Peggy and I have talked a lot about that. I think that there were several suggestions in the slides about how to deal with someone who is a juror who is blind, who can't see exhibits, for example, having audio descriptions that are pre-recorded. Many exhibits in trials are provided to the court in advance, either by list or otherwise, so the court should be able, in many, if not most circumstances, to have an audio recording available. You can have the equivalent of a qualified reader describe the exhibits to the juror. So that's an issue, or that may be an accommodation. Again, you can learn more by talking to the juror, but please remember, you cannot excuse someone just because they're blind. That having that interactive conversation with the juror is very important. And then describing the types of accommodations that you have available to ensure that they have full access to the right to serve as a juror, which is jury service is considered an ADA covered program, service, or activity.
Great. So I'm hoping we have a few more minutes for a couple more questions. Cheryl is asking from New Jersey. Welcome, Cheryl. The 2010 ADA design standards do not require automatic door openers. What standards is the DOJ citing as the basis for not having compliant entrances?
The requirement is that the doorway has to be accessible. There are requirements for the weight of the door. So if your door does not meet ADA weight requirements, how am I going to open it? If I'm in a protected class covered by the ADA. So yes, you don't have to provide, it's true, you don't have to provide automatic doors, but then you do have to answer the question, if your door is too heavy, according to the ADA, then what do? How does someone open it? That's something for you all to determine by doing your own self-evaluation and answering the rhetorical question. This door is too heavy. What do? And maybe there's a way you can loosen the tension. Maybe there's a way you can replace the door with a lighter door. So there are options to pursue. But at the end of the day, if you can't reduce the tension, or the door is too heavy under the ADAG requirements, you have to make it accessible. How you do it is largely up to you, but you're going to have to ensure that the heavy door is somehow accessible according to the ADA.
Thank you.
All right, let's see. Do we have time for one more question, Bruce? Okay, so Stephen wants to know, what is an example, if any, of an unreasonable accommodation for a blind and or deaf prospective juror?
Great question. I think that, let's say, for example, you're in a county where there is no ready access to an in-person sign language interpreter. You have no one on staff who can communicate in sign language and is a qualified interpreter, but you do have access to a sign language interpreter by video remote interpreting. So while that's not ideal, it is a substitute, or can be a substitute, for an in-person interpreter. So insisting that, no, I must have an in-person interpreter and they have to be here from 7 o'clock in the morning until 6 o'clock in the evening, that may well be unreasonable. I haven't really heard that in the court context. I hear it all the time in healthcare. So I think that's an example of an audio accommodation that may be unreasonable, with somebody who is blind insisting that, let's say there's a transcript in the particular trial where the juror is serving. There's a transcript of 5,000 pages from some other court hearing, and that juror insists that it all be printed in Braille. That could well be an unreasonable accommodation, but keep in mind that the whole undue burden thing is going to be difficult to prove, but it could well be unreasonable to expect you to print a 5,000-page document in Braille. But the thing with the ADA to keep in mind, all of these are individualized case-by-case determinations. So I can't say absolutely that printing a large document in Braille is per se unreasonable, is the ADA doesn't really work like that. But thinking that it could be, and keeping that in mind and coming up with an alternative is something that I would suggest.
Great. Thank you, Bruce. Some of the participants would like to know if we can have access to your PowerPoint today. Is that okay?
Well, that's
Excellent.
fine.
Thank you. If you are interested in receiving a copy of Bruce's PowerPoint, please go ahead and send us your request to the ADA address, ada@nmcourts.gov, and let us know, and we'll be happy to send it your way. I'd like to take this opportunity to thank everyone for joining us today. This is a very important topic, lots to talk about. I'm sure we could use even more time, but it's been great seeing everyone. And I also like to say thank you, Megan, for fantastic work today. Great. Thank everyone. Have a great afternoon.
Bye.
Bye, thank you.
Thank you.